Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers the right to remain silent, identification laws, and reasonable suspicion, and is brought to us by LAC Audit's channel. Be sure to check out the description below and give them the credit that they deserve. In a video posted on December 14th, 2023, Officer Reeves and Sergeant Brian Gilmore of the Upper Chichester Township Police Department responded to a call regarding a quote-unquote suspicious vehicle parked on the side of a public street in Upper Chichester, Pennsylvania. The interaction that followed was recorded by the driver of the vehicle, who appears to be the owner of the LAC Audit YouTube channel, and who we will refer to as Mr. LAC.
Hey sir, how you doing?
I'm good. How are you?
I'm good. I'm Officer Reeves, Upper Chichester Township Police Department. The reason we're here is we got a call for a suspicious vehicle, okay? Someone passed her by or whomever called said it was a white vehicle sitting along the power lines.
I'm sitting on a public street minding my business. That's all I'm doing. Yeah.
Okay, well we got a call for a suspicious vehicle. We're just checking on said vehicle. Are you the owner of the car, sir?
I'm sorry, I'm not going to answer any questions. I invoke my Fifth Amendment right to remain silent. Can I get a badge number?
Yeah, 51. Would you like the supervisor's badge number too?
Yes, please.
It's 37.
And his name?
Sergeant Brian Gilmore.
Brian Gilmore. Okay.
Would you like to speak to him as well?
No, thank you.
Okay.
I just want to mind my business, man. People drive by here, see me parked here doing nothing wrong.
Fifth Amendment right not talk to us.
Yes, because I'm not doing anything illegal, right? Literally just parked in a public street.
Mr. LAC informs the officer that he would like to exercise his Fifth Amendment right not to answer questions. Under the Fifth Amendment to the U.S. Constitution, quote, "No person shall be compelled in any criminal case to be a witness against himself." The primary application of this right occurs during criminal court proceedings, where an individual may assert their privilege to, quote-unquote, plead the Fifth. And although the Supreme Court has not explicitly ruled that the Fifth Amendment applies in the context of Terry stops or traffic stops, the court has repeatedly stated that an individual stopped by the police for investigation cannot be compelled to answer questions. For instance, Justice White wrote in his concurring opinion to the infamous Terry case that, quote, "Given the proper circumstances, it seems to me the person may be briefly detained against his will while pertinent questions are directed to him. Of course, the person stopped is not obliged to answer, answers may not be compelled, and refusal to answer furnishes no basis for an arrest, although it may alert the officer to the need for continued observation." This concurrence has been cited many times, including the 1984 case of Berkemer versus McCarty, where the Supreme Court held that officers may ask questions during routine traffic stops without giving Miranda warnings regarding the right to counsel and the right to remain silent. In reaching this conclusion, the court noted that during a Terry stop, quote, "The detainee is not obliged to respond, and unless the detainee's answers provide the officer with probable cause to arrest him, he must then be released." Now, despite the clear language of this statement, it is what is referred to in the legal world as dictum, short for obiter dictum, which is Latin for something said in passing. Dictum is a statement in an opinion about a topic that is not necessary to be resolved in order to decide the issues in question in the case, and concurring and dissenting opinions are typically considered dicta as well. Accordingly, statements that are considered to be dicta are not legally binding on other courts, although they can still be used to persuade courts in future cases. For this reason, lower-level courts have frequently determined that the law regarding the right to remain silent at a traffic stop is sufficiently unsettled to deny recovery under the doctrine of qualified immunity to individuals who allege that they were unconstitutionally arrested for refusing to cooperate with police investigations. Accordingly, while it is likely that a court would find that Mr. LAC could not be arrested for refusing to answer questions, the legal contours surrounding the origin and existence of the right to remain silent during a Terry stop have not yet been fully decided.
Sarge requesting your ID.
I'm not going to provide that. I didn't commit any crimes. I'm parked legally in a public street, doing nothing wrong.
What's that? He says no to the ID. He's parked on public street doing nothing wrong.
That's right. Just because somebody called in a suspicious car doesn't mean you're doing anything illegal. Did they specifically identify something illegal that I was doing?
At this point, the reason we're requesting the identification is number one, we identify everybody we talk to. It's part of our routine. It's accepted, and it's something that's been approved by the Supreme Court,
it's not been
and the United States Supreme Court.
It's not been approved by any Supreme Court.
Okay, all right. Well,
unless
you
have reasonable,
disagree all you want, but just because you think so doesn't mean
unless you have reasonable suspicion of a crime.
Okay. Well,
I don't have to provide any ID, sir.
Sergeant Gilmore claims that the Supreme Court has approved the practice of officers identifying anyone they come into contact with, but the driver argues that he does not need to provide identification unless the officer has reasonable suspicion. Beginning with the landmark Terry case, the Supreme Court has consistently recognized that an officer has the authority to briefly detain an individual for investigation when they have reasonable suspicion to believe that an individual may be involved in criminal activity. Likewise, in the 2004 case of Hybel versus 6th Judicial District Court of Nevada, the Supreme Court held that, quote, a state law requiring a suspect to disclose his name in the course of a valid Terry stop is consistent with Fourth Amendment prohibitions against unreasonable searches and seizures, meaning that a citizen can be arrested and prosecuted for refusing to identify if they are legally detained based on reasonable suspicion, and state law requires them to identify themselves under the circumstances. However, Pennsylvania has not passed a stop and identify law requiring individuals to identify themselves during valid Terry stops. So, even if the officers had reasonable suspicion to believe that Mr. LAC was engaged in criminal activity, it is likely that a court would conclude that they could not arrest him for refusing to identify in this situation. Further, despite Sergeant Gilmore's contentions to the contrary, the Supreme Court has repeatedly held that police officers cannot require citizens to identify themselves without reasonable suspicion that they are involved in illegal activity. For example, in the 1979 case of Brown versus Texas, the Supreme Court concluded that the application of a Texas statute to detain an individual and require him to identify himself violated the Fourth Amendment prohibition on unreasonable seizures because the officers lacked any reasonable suspicion to believe he had engaged in criminal conduct. In reaching this conclusion, the court noted that, quote, in the absence of any basis for suspecting appellant of misconduct, the balance between the public interest and appellant's right to personal security and privacy tilts in favor of freedom from police interference, and that although stopping and demanding identification from an individual without any specific basis for believing he is involved in criminal activity may, in some way, further the public interest in prevention of crime, now quoting again, the guarantees of the Fourth Amendment do not allow it. When such a stop is not based on objective criteria, the risk of arbitrary and abusive police practices exceeds tolerable limits. Now, in this situation, a court would likely find that the officers did not have reasonable suspicion to detain Mr. LAC, as they seem to have simply received a call about a quote-unquote suspicious car and indicated no other specific or articulable reasons to detain Mr. LAC. Accordingly, even if Pennsylvania had a stop and identify law requiring individuals to identify themselves during Terry stops, a court would likely find that the officers lack the reasonable suspicion that is constitutionally necessary to arrest or prosecute Mr. LAC under such a statute.
But you're on one of our streets in our town, and in order for you to leave, you're going to have to be legally able to drive. Who
pays for these streets, sir?
Upper Chichester Township.
The township, right? The people. So that means I can park here, I can travel through here also. I can stop on the streets. It's not illegal for me to do that. Did I commit an infraction?
You didn't say you're doing anything illegal at this point.
So then I'm not
vehicle.
providing any idea if I didn't commit anything illegal, if I didn't do anything illegal. There's an investigation that you have to conduct.
Yes.
So far, in your investigation, what have you concluded that I've done that's illegal?
That I have somebody that's refusing to provide identification.
And that's not illegal. Am I under arrest? Sir.
You don't need to commit a crime for us to ask you to provide ID, sir.
Yes, you do. Yes, you do. You need RAS. Without RAS, there's no probable cause.
I have somebody that called in that this vehicle's been sitting here for an extended period of time.
So if someone calls in here, a black guy is sitting here, is that illegal?
Nobody said anything about you being black.
Well, I'm saying if they do. Is that illegal? Can you just come here and identify me?
They didn't say you were a pink flamingo either. So
well, that's fine. But I'm not providing any ID. Where do we go from here? I didn't do anything illegal. You threatening me with arrest.
I'm telling you that you need to provide identification.
I'm not providing any investigation. Talk to them. Do your investigation. Do a thorough investigation. You just don't come here and talk to me. Talk to them. See what I did. I didn't do anything wrong. You're not going to force me to identify. But do an investigation to see if I did anything wrong.
The first step of my investigation is requiring you to provide identification.
I'm not providing any ID. I did nothing wrong. You pulled up here because someone called and say, hey, I need your identification. Doesn't work like that. I'm not providing it. Until the laws of America change where we have to identify because an officer comes and say, hey, give me identification.
Well, you need to work on reading up on the court.
I know exactly what it says.
Okay, what does it say?
I know what it says. I have a First Amendment right to record. I have a Fourth Amendment right.
Nobody said you can't record.
Well, let me finish. Let me finish. I have a Fourth Amendment right to be safe in my documents and papers. Unless I commit a crime, I do not have to identify.
I'm not unreasonably searching or seizing anything at this point.
You're trying to, yes, you're trying to seize my ID.
I'm asking you to provide identification. It's part of my job.
And I'm respectfully refusing that. In the state of Pennsylvania,
if you're operating a motor vehicle, which is what you're doing.
I'm not operating a motor vehicle.
You absolutely are.
I'm parked on a public street.
You're in command and control of the vehicle.
I'm parked on a public street.
If you were under the influence of alcohol or another drug, I could arrest you for DUI, but you're not.
I'm parked on a public street.
Okay.
Good. That's all I'm doing here. Doing nothing illegal.
You're the subject of an investigatory detention.
Sergeant Gilmore informs the driver that he is obligated to provide his identification under the state vehicle code because he is operating a motor vehicle and is the subject of an investigatory detention. Under Section 6308 of Title 75 of the Pennsylvania Consolidated Statutes, quote, "The operator of any vehicle reasonably believed to have violated any provision of this title shall stop upon request or signal of any police officer and shall, upon request, exhibit a driver's license." Now, although the term operator is not defined, in the 2021 case of Commonwealth versus Singletary, the Superior Court of Pennsylvania indicated that in order for an individual to operate a vehicle, they must, quote-unquote, drive or move it. And since the officers approached Mr. LAC while his vehicle was parked, there is an argument that this statute would not apply to this interaction. Likewise, according to Section 1511 of Title 75 of the Pennsylvania Consolidated Statutes, quote, "Every licensee shall possess a driver's license issued to the licensee at all times when driving a motor vehicle, and shall exhibit the license upon demand by a police officer." The term driving is not defined, but Section 102 of the same title of the Pennsylvania Consolidated Statute states that a driver is a person who drives or who is in actual physical control of a vehicle, which seems to indicate that being in actual physical control of a vehicle is not considered the same as driving under the state traffic code. It should also be noted that this statute states that an individual can avoid conviction by producing a driver's license that was valid at the time of the demand within 15 days of the demand or the filing of the citation, indicating that the primary purpose of the statute is to ensure that drivers are licensed, not to enforce compliance with identification requests. Further, regardless of whether or not Mr. LAC was driving or operating the vehicle, the Supreme Court held in the 1979 case of Delaware versus Prouse that, quote, "Except in those situations in which there is at least articulable and reasonable suspicion that a motorist is unlicensed or that an automobile is not registered or that either the vehicle or an occupant is otherwise subject to seizure for violation of law, stopping an automobile and detaining the driver in order to check his driver's license and the registration of the automobile are unreasonable under the Fourth Amendment. Accordingly, because it is highly unlikely that the officers had reasonable suspicion to believe that Mr. LAC had violated the law, it is improbable that a court would conclude he was required to display his driver's license in this situation, even if it determined that the relevant traffic statutes applied to the stopped vehicle."
Can I get a case number?
Nope.
I need a case number. I want this documented.
Okay. We
Can I get a
document
case
everything.
number?
You're welcome to go to the police station and request a report.
Phone
We're not going to know who you
37.
are because you didn't provide us any ID.
I don't have to.
You'll probably get a citation for failure to provide driver's license.
Oh, yeah, let's go ahead. Go ahead. Go ahead. Let's do that. You're a tyrant. That's what you are. You're threatening me for doing nothing wrong. Hey.
What do you want?
Him. I'm not talking to you. This guy here. I'm speaking to him, sir. I'm allowed. He's funded by the taxpayer.
What do you need?
Sir, can I get an incident number, please?
I don't have an incident number yet.
So you're not providing incident number?
I don't have an incident number until I go back and do the report. I can't just pull one out of thin air.
All right, let me
So,
talk to
well, he doesn't have one either, and that's the supervisor.
I just want to talk to him. It's just fine. You're gonna harass me
Stay away from my dog.
for doing nothing wrong. Stay away from your dog. I'm not allowed.
Stay away from the dog.
I'm not approaching the dog.
You walk right close to the car.
Is it illegal to be close to the car? Hey, do you mind giving me an incident number, please?
Yep.
That's all I
My
wanted.
last name's Clapp, badge number's 44.
Thank you, Clap.
Hey, have a good one.
I just want an incident number. Literally, that's all.
We don't
Because-
generate an incident number until it clears. You can get it tomorrow, okay?
So no
You
incident
go to the
number?
police department? No, not right now.
Okay.
All right?
Yep. Just walk next to the car again. Is that illegal?
Very little information is available about this encounter, and it is unclear whether Mr. LAC was ultimately issued a citation, or if he has filed a complaint, or intends to pursue legal action against the police department or the officers involved. Overall, Sergeant Gilmore gets a C- for demonstrating a blatant misunderstanding of the Fourth Amendment, maintaining a hostile and authoritarian demeanor throughout the encounter, and implying that he could arrest Mr. LAC for refusing to identify himself. Now, while I appreciate that Sergeant Gilmore ultimately chose not to arrest Mr. LAC for exercising his rights, his assertion that the Supreme Court allows him to identify anyone he comes in contact with is unquestionably false, and it gives rise to serious concerns that he is unlawfully detaining individuals and requiring them to identify themselves, particularly given the fact that Pennsylvania is not a stop and identify state. Although the Supreme Court has made it clear that officers do not violate the Fourth Amendment by requesting that an individual identify themselves or provide identification, even in suspicionless consensual encounters, the case law is equally clear that identification cannot be compelled absent reasonable suspicion. And the fact that Sergeant Gilmore was so confident in his mistaken belief that he can identify anyone that he told Mr. LAC that he was the one who needed to study the law further is highly concerning. Mr. LAC gets an A for remaining calm and reasonable throughout the encounter, firmly asserting his rights to refuse to answer questions and to refuse to identify himself, and working to promote accountability by filming the encounter and then sharing it on his YouTube channel. However, while I believe that overall Mr. LAC did an excellent job during this encounter, I did notice that he stated on multiple occasions that he does not have to identify himself if he has not committed a crime. The distinction is a bit subtle, but in actuality, the law in states that have stop and identify statutes typically requires individuals to identify themselves when an officer has reasonable suspicion to believe they are involved in criminal conduct, regardless of whether or not they actually are. As reasonable suspicion is not negated by an individual's actual innocence, there may be situations where citizens who have not committed any crimes whatsoever are still legally obligated to identify themselves. As Mr. LAC also stated that reasonable suspicion was necessary, I'm not sure whether he was confused about this concept or simply misspoke, but I wanted to take this opportunity to address this issue as it is a somewhat common misconception in the auditor community. Despite this semantic issue, I believe that Mr. LAC should be commended for the way he handled this interaction, and I would encourage him to continue to learn about constitutional law and conduct audits. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.